Welcome back to the Constitutional Clarion. In my last video, I had a bit of a rant about how political parties sneakily collect your personal data by sending out postal voting request forms and then getting you to return the form to the party instead of the Australian Electoral Commission, the AEC, so that the party can collect your data before passing it on. This raised the question of what political parties are allowed to do with that data and whether the privacy rules which apply to everyone else apply to political parties. So that's what I'm going to look at in this video, and you won't be too surprised to learn that politicians have given themselves quite significant exemptions. Let's start with the access to the data on the electoral rolls. In Australia, it's compulsory for all people who are qualified to vote to enrol to do so. The Commonwealth Electoral Act 1918 requires electoral rolls to be kept and provides that they must set out the names and places of living of each elector and such further particulars as are prescribed. The Commonwealth is permitted to have joint rolls with the states, which may mean that some additional information is also included on a roll if a state law provides for it. People can inspect the Commonwealth electoral rolls at certain AEC offices. Voters who would have a security risk if their address was publicly revealed can be listed as silent voters so that only their name and division appear on the roll, not their address. Section 90 capital B of the Commonwealth Electoral Act says that the AEC must give information from the electoral rolls to certain persons and organisations. It sets out quite a complex list of who gets what, so check it if you do need more precise information. But the gist of it is the elected members, senators and registered political parties get access to the electoral roll with respect to the division or state or territory that the politician represents or the jurisdictions in which the political party operate. Once the rolls are closed for an election, parties and elected politicians can also access the relevant certified list of who can vote at the election. They can also get what's known as a habitation index, which lists electors arranged by reference to where they live. After the election, they can also access information about who actually voted and at which polling place they did so. When access is given to MPs, senators and political parties to the electoral roll, it's done so electronically. The data can be downloaded and used by their office staff, but also by their delegates, which include what the AEC rather coyly describes as data bureaus. And that means commercial marketers and data harvesters. The data provided from the electoral roll includes a person's name and enrolled address, their postal address, sex, date of birth, title, some details about their enrolment status, and which federal and state electorate and local government area they live in. However, the data does not include other contact details such as telephone numbers and email addresses. And that's why the political parties still seek to collect that data by using that ruse of assisting electors to get a postal vote and then scanning that information that they provide. In the past, parties also used to cross-check the electoral roll against the electronic version of the white pages for telephone numbers, but of course that's not really terribly useful these days. Instead, they now pick up such information from the postal voting forms, if they can get them, door knocking, contact by voters with electorate officers, and from commercial data harvesting bodies as well. In what ways can politicians and political parties use the data that they get from the electoral roll? Are there any constraints? Well, there are. Section 91 capital A of the Commonwealth Electoral Act makes it an offence for a person or organisation who received voter information from the electoral roll under Section 90 capital B to use that information other than for a purpose that is permitted. and the penalty for failing to do so is 100 penalty units. Well, what are those permitted purposes? Well, the permitted purposes for members, senators and political parties are any purpose in connection with an election or referendum, which of course is very broad, research regarding election and ballot matters, monitoring the accuracy of information contained on an electoral roll, and the performance by members and senators of their functions as such. In addition, Section 91 B says that a person must not disclose information that the person knows or has reasonable grounds for believing came from electoral roll data provided under Section 90B to the parties, candidates and politicians, unless they disclose it for one of those permitted purposes. And the penalty here is higher, it's 1,000 penalty units. It also provides in that section that a person shall not use this information for a commercial purpose. So the marketing companies that political parties give your electoral information to for the purposes of sending out political advertising and messages to you would commit an offence if they use that data for the commercial purposes of any of their other clients. Whether or not anyone actually investigates and enforces that, however, who knows? The AEC also issues guidelines on the use of data obtained from the electoral roll. The guidelines state that the electoral roll should be accessed through a secure network, that login credentials should be kept secure, that any data downloaded should be stored securely and protected from unauthorised access. But these are just guidelines, and it assumes competence and care for which political parties are not necessarily renowned. But surely politicians and parties are subject to the same rules as everyone else concerning privacy and data collection? You might think that, but you'd be wrong. Political organisations and their contractors, subcontractors and volunteers are not subject to the rules relating to the secure storage and retention of personal information sourced from the electoral roll. This is because they are exempt from the application of the Privacy Act 1988. First, registered political parties are expressly excluded from the definition of organisation in Section 6 C, so they're not bound by the national privacy principles. In addition, Section 7 C states that acts done by political representatives, such as members of parliament or local councillors, or done by their contractors, subcontractors, or the volunteers of registered political parties are exempt from the Privacy Act if they are done for any purpose in connection with an election, a referendum, or the participation of the political representative or the party in another aspect of the political process, whatever that means. Apparently, this also facilitates political parties and politicians passing dirt sheets of personal information on opponents to journalists without being subject to privacy constraints. It also means that political parties are not obliged to report data breaches and loss of personal information because they're not organisations under the Act. The Australian Law Reform Commission, in a 2008 report, proposed either that this exemption be removed from the Privacy Act or that the Commonwealth Electoral Act be amended to require that those who are given access to the electoral roll take reasonable steps to protect the information from misuse and loss, unauthorised access, modification or disclosure, and that they destroy the information when it's no longer needed for a permitted purpose. It appears that neither proposal was actually adopted. Now, this is not the only exemption that politicians have given themselves. They also exempted registered political parties, independent MPs and electoral candidates from the application of the Do Not Call Register Act 2006 if they make unsolicited telemarketing calls for political fundraising or selling goods or services, such as party merchandise. Unsolicited calls that simply involve political advertising and messaging are exempt anyway because they're not commercial in nature. Similarly, registered political parties are exempt under the Spam Act 2003 even when they are sending commercial electronic messages in relation to goods or services, as long as they include information about who authorised the sending of the message. Politicians justify all these exemptions on the ground that the Constitution impliedly requires the maintenance of freedom of political communication. Well, yes, it does, and that's important. But as anyone who watches this channel would well know, laws can be enacted that burden the implied freedom of political communication if they are for a legitimate purpose that's consistent with the system of representative and responsible government, and if the law is reasonably appropriate and adapted to serve that legitimate purpose in a proportionate manner. Protecting the privacy of people would amount to a legitimate purpose, and it doesn't seem to me to be disproportionate in any way to allow people to opt out of receiving political communications to their personal phone or email address if they do not wish to receive them. There are plenty of other ways by which political messages can be conveyed to voters. One might well ask also, how would it unduly burden the implied freedom of political communication to require political parties to protect the personal information of voters that they hold, to correct inaccurate information that they hold, and to report data breaches? The collection and mishandling of personal information of Australians can put Australians at risk of harm through hacking, impersonation, and scams. These databases held by political parties may contain inaccurate information. Now, I know this because for many years, my then local member used to send me letters explaining how his party's policies would assist my dry cleaning business. Now, as you've probably guessed, I do not own a dry cleaning business. I didn't, however, seek to correct his party's database. I actually found it quite a good reminder for how incompetent his party was and why I should therefore think twice before voting for its candidates. Inaccurate information on political databases, however, could be used to the detriment of constituents, particularly if it's made public and passed on to others. Even the collection of accurate information can be potentially dangerous depending on the purposes for which it may be used. In Canada, for example, there was a controversy some years back when special greetings for Jewish New Year were sent to Jewish constituents. Recipients, understandably, became concerned as to why political parties were assembling databases that identified Jews. One never knows how such databases might be used in the future. When the Australian Law Reform Commission put out a discussion paper asking whether the exemption from the Privacy Act should be removed for registered political parties back in 2006, it received considerable support for the removal of that exemption. Some argued that the preferential treatment given to registered political parties undermines public trust in the political process. And that's a real problem when trust in political parties is already falling, and it might well also corrode trust in the democratic system. We all know that such exemptions survive because it's in the interests of all the political parties to keep them going. But it's also true that political parties are sensitive to community anger, particularly during an election campaign. So if you are angry about political parties data harvesting by getting people to send their postal vote application forms to them, or if you resent their exemption from the Privacy Act and any proper rules for keeping your data safe, or if you just fed up with receiving robocalls and unsolicited advertising coming to your phone or your email address, then the next time you see a candidate outside your shopping centre or at the train station canvassing for votes, let them know. The message will be fed back to political parties if enough people complain, and the parties might then come to the view that the exemptions they've given themselves are actually doing more harm than good. One can only hope. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.